Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because you know, on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it, and all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous. Okay? All right, go back with the bailiff. Yes, ma'am. Let me, thank you. Good morning. Are you Stephen, is it Bodwin? Bodwin.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Bodwin, in cause number 25 DCCR 0940, and so count 1 only and then to the lesser attempted, correct?
Correct.
The state's elected to proceed on count 1 only, and in count 1 to the lesser offense of an attempted robbery. That makes it a 3rd-degree felony, and that's from June 24th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bodwin is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and then we'll come back later for sentencing. Miss.
I think he may have a parole issue, Judge.
He does.
We need to
Oh.
check on. In my read of this, if this is the only thing he's dealing with parole, and my experience with parole, I don't anticipate that they would probably revoke him based on these underlying facts. But
Okay.
I think it would be best if we
Okay,
maybe see
just
what
leave everything the same.
information we can get, and if we need to withdraw this and plead to something else, we can.
Okay, yeah, and if y'all can look into that and see if
Yeah.
parole, have they already been out for a hearing?
Yes, ma'am. I had a revocation hearing on August the 19th,
Mm-hmm.
and they chose to reinstate my parole.
Okay,
But then when they brought the answer on August the 22nd, she gave me a new violation for the same allegations that I'm dealing with.
Okay.
Same exact allegations.
Okay.
They just voted on the revocation.
so they voted to revoke now, or
No, they haven't voted on
they
it.
haven't done it
They
yet?
did vote, and then in the same instance, she
Right.
gave me a new violation report.
Do you know when they're coming, you have no idea when they're coming to
No,
do
ma'am,
that
I was
again?
scheduled for a hearing last week, and she didn't show up.
Okay, if y'all will work to see maybe when that's gonna happen so that we know, obviously if they're gonna revoke you, it doesn't make sense to put you on probation. If they're not, then we can go forward with this, but we'll find out before sentencing. Okay, you can go back with the bailiff. Good morning, you're Logan Eaglin?
Yes, ma'am.
Let me get this. Mr. Eaglin, in cause number 25 DCCR 0897, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from October 26th of 2024. Your indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, March 1st of 2013, in 2 cases on that same date of burglary of a habitation. And then after those were final, you were convicted of possession of a prohibited substance in a correctional facility, a third-degree felony, from September 3rd of 2015. What that means is that if you go to trial and you're found guilty and those prior convictions are true, you would be considered a habitual offender. The minimum punishment would be 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 20 years in prison, which means if you did that, I'm guessing that would be to just count one only. So you would only be pleading to the offense that you're charged with. And the most I could give you is 20 years. I could give you 20, I could give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to reject that offer and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, is there any reason to believe that that offer would change, Mr. Smith? So I do want to make sure you understand, Mr. Eaglin, that after today, unless there is new evidence that comes up that the attorneys don't know about already, I will not accept this a plea agreement after today. Once your case goes on the trial docket, it either, if you plea, it's just something different, or we're going to let a jury decide. You understand?
Yes, ma'am.
All right, so we'll get it set on the trial docket. Mr. Eaglin, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Lewis, you are released. We will appoint someone today, Mr. Eaglin. They should be out to see you very soon to begin preparation for trial.
Thank you.
Okay, yes, sir. You can go back with the bailiff. Good morning. Are you Almeida Miles? And Ms. Miles was previously in court, entered a plea of guilty in cause number 24, DCCR 2330, to tampering with physical evidence. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
Are there any additions or corrections?
None that I'm aware of, Judge.
In addition to this pre-sentence report, I've also received and reviewed a number of jail incident reports. Has everyone had an opportunity to review those? And you're 19? Why haven't you been acting right in the jail?
Most of the reports are not true. One time I did not uncover my face on the video. I did, because I was asleep, and she didn't wake me up. Ms. Boa didn't wake me up. When I got here in June.
So she's lying when she says she tried a few times, and then she taps you, taps your bed, kicks your bed a little bit.
That day, Ms. Boa never tapped me. And then in June, I got in a fight when I first got here. The girl swung at me first.
Okay.
That's accurate, what it says, the girl here with the closed fist.
Yeah, I mean, if you get hit first, that's not the ones that I'm so worried about. It's the... eating at your bunk when you're not, I mean, it's not even big stuff. It's just not following the rules. And if you can't follow the rules in jail, why should I believe that you can follow the rules on probation? When you're in jail, when you're on probation, when you've committed a felony, you don't get to make certain decisions for yourself anymore, right? Now, you're not going to be like every other 19-year-old and get to just do what you want when you want. You're going to have to do what either jail says or what I say or anything like that. If I'm going to follow this agreement based on the nature of the offense and based on the age and all of this, we're going to get you some help up front to be making better decisions. Otherwise, I'm not going to follow the agreement. Things could be a whole lot worse. Do you understand? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You're not going to get out of jail today. You're going to go to ISF instead, and you're going to hopefully pay attention and learn how to make better decisions. You're still young, you're still immature, but you're going to have to make some very mature decisions if you don't want to go to prison, and that's going to be to help you make those better decisions. Now, here's the thing. If you're in our jail and you start before they send you in the next week or two, or if you're in ISF and you are acting up and not following rules, putting something on your head that you're not supposed to, eating where you're not supposed to or when you're not supposed to, talking about whatever it is, I don't care, then you could be revoked just for not following the instructions. And you'll never get out and even have an attempt at probation. Do you understand? So whatever's going on and whoever your buddies are in there, you need to tell them, just sit there, do everything you're supposed to do. All the playing around's done because you want to get out and make something of your life. And if they don't want to, that's going to be on them. If you keep doing all this, you're going to have a felony conviction and you're going to go to prison. It's that simple. You understand? The part of this probation that is so good is that you don't have a conviction right now. And if you're successful...
This might be the most generous break we've seen all morning. Deferred adjudication means if she successfully completes probation, she avoids a final felony conviction. That's life-changing. Jobs, housing, voting rights, all preserved. But here's the catch. Deferred probation is fragile. One violation, boom. The judge can sentence her anywhere in the full punishment range. The judge is practically spelling out the blueprint for staying free. The question is, will she follow it? Because 19 years old with a second chance is one thing. 19 years old with a prison sentence? Very different story.
And you complete your probation, you are never going to be a convicted felon. So this is a great opportunity. But if you do violate in any way, you'll be back in here, you'll be a convicted felon, and you could go to prison anywhere in that range of punishment, which is between 2 and 10 years. All right? I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you. You can go back with the bailiff. Before everything gets closed out. Good morning. You're Linton Arsenault? And Mr. Arsenault, are you currently sick?
Ma'am?
Are you sick right now?
No.
Would you pull that down for me just so, there you go, I can hear you better in the hearing. And Mr. Arsenault, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor. None from the defense.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those. It looks, to defense lawyer, to me, it looks worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to penitentiary. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light.
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I brought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next time, the next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right, thank you. Mr.
Your Honor, I
Hoffpower?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version. I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at. And if you aren't, then you're supervising yourself, and that's the problem. So the only reason things the state, and it's up to the court, obviously, I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't gonna come. And he's not gonna report, so we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arsenault, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part. You didn't say that?
No, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register And you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I went
sense.
in front of Judge Stevenson. What it?
No, you went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender.
Yes, ma'am.
So you did know you have to register because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay.
Yes, ma'am.
All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Ms. Holmes, you have Jordan Thomas. Oh,
She just left, she'll be right back.
okay, I'll hold it. I'll hold hers. Thank you, Mr. Lewis. Mr. Lewis, you have Reagan Benoit.
Yes, ma'am.
Benoit. Reagan.
Good morning. Yes, sir. Good morning. Are you Reagan Benoit?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Benoit, in cause number 25 DCCR 0880, you're charged with the state jail felony offense of attempt to take a weapon from an officer from June 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0881, you're charged with, let's see, are we going on the count one only in that case?
Is that the one we're doing 6 months on?
6 months was on the weapons, 2 years on
This is the TDC.
This is the 2 TDC.
Mhm.
I mean, yes, Judge, we'll abandon that.
Okay, let me pull this up.
So we're doing 6 on attempted.
the, yeah, 620, 2 on assault.
Okay. All right, so in 25 DCCR 0881, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a security officer from June 1st of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
State tenders number one in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Benoit is not competent?
No objection.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25 DCCR 0880, find sufficient evidence to find you guilty, and at this time find you guilty of attempt to take a weapon from an officer, sentence you in accordance with your agreement to a term of 6 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0881, I'll find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to and these cases will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. And firearm is, I have to read the whole thing to you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You go back with the bailiff.
Thanks, Judge.
See, Luther Sharp, Mr. Parker?
Reset.
Okay, thank you.
Clark and trustee reset.
And trustee was reset. All right, what about Stephen or Stephen Boudwin?
I think it was Bodwin.
Bodwin?
You should have plea papers.
Got it, thank you.
This is court permission. I would move to proceed on the lesser included attention.
There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing, just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I assume the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened, and hopefully not engaged in the type of conduct that caused us to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So, yeah, obviously, if the court repeats 5, the court's inclined, because of her criminal history, to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history. that she wanted to address as well, is that right? You have to say for yourself.
I do apologize for the situation that went on, and I wish that anybody that was involved in the case will see that I'm really serious and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full wage.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail. And then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, you know, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
Judge, I'm sorry, the wrong case number.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry. 25 DCCR 0979 finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just said on the record, she wanted to make sure it's not aggravated. This is not.
Good morning, sir. Are you Jesse Salinas?
Yes.
And Mr. Salinas is charged with sexual assault of a child and aggravated sexual assault of a child. Oh, wait, let me go. Hold on. These are rejections. Go through this. Mr. Salinas, in cause number 24, DCCR 1350, you're charged with the second-degree felony offense of sexual assault of a child from May 15th of 2015. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, we are.
And then in cause number 24, DCCR 1351, you're charged with the first-degree felony offense of aggravated sexual assault of a child from January 1st of 1972. When in that case, if you're found...
And just like that, the temperature in the room changes. First-degree felony, 5 to 99 years, or life. Notice something critical. They asked for no plea offer. That means this is going to trial unless something drastic changes. And the judge makes it very clear, once it's on the docket, negotiations are over. That's a power move. It forces decisions now. Trial means witnesses, evidence, cross-examination, and in cases like this, emotional testimony. So here's the big question. Is rejecting a plea confidence, or is it a gamble that could cost decades? We'll find out.
Guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, Your Honor.
In each of those cases, I have here on the computer plea bargain rejections that have your signature on them with Mr. Gertz. This shows that there is no offer, that y'all have asked for no offer. Is that correct?
That is correct.
And that you intend on going to trial in each of your cases. I want to make sure you understand that after today, I will not accept a plea agreement. So if you want to negotiate, now's the time to do it. Once it's on the trial docket, it will go to trial. All right, I just want to make sure you understand.
Yes.
And you want to go forward and have your cases set for trial, is that correct? All right, we'll get them set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back and ready for trial.
Thank you.
Mr. Gertz, you have Jonathan Zekaff. This time.
This time, it won't happen again.
Thank you, good morning.
Hey. Nobody's heard of a delayed outcry?
I know.
Well, I had to wake up and they're like, Tom,
52 years.
What are we talking about?
I know. All right, are you Shalora Dawson?
Yes,
And Ms. Holmes, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Dawson, in cause number 24 DCCR 2038, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from August 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
yes,
And are you pleading guilty because you actually did what they've charged you with?
yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes,
Do you fully understand them?
yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
yes,
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? State, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Dawson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there. Okay? See you back at sentencing.